Let's bring in Jamil Jaffer, founder and executive director of the National Security Institute at the Anthony Scalia Law School at George Mason. He's also on the board of directors for the Greater Washington Board of Trade, has served in the Justice Department's Office of Legal Policy. It's good to have you. Thanks so much for the help today. We need it.
Absolutely. Well, thanks for having me on.
What is your overall reaction to the decision?
Well, look, a very clear rebuke of the Trump administration's effort to impose tariffs in this way through the International Economic Emergency Powers Act. As you guys were talking about earlier, obviously the president has a lot of authorities he could be using. He's chosen not to use them thus far. But at this point, he's going to have to go to those authorities and not rely on IEPA. The court came out pretty clearly, 6-3. Justices Gorsuch and Barrett joining Justice Roberts' opinion. Justice Gorsuch writing separately to explain exactly why he joined that opinion in full. But he took on a couple of other ideas in some of the other opinions, as well as the dissents, strident dissent from Justice Kavanaugh and Justice Thomas as well. So a lot to sort out here, but a very clear rebuke of the Trump administration's effort in this way.
Right. I'm just looking through the majority here. The government cannot identify any statute in which the power to regulate includes the power to tax. The court is therefore skeptical that in IEPA and IEPA alone, Congress hid a delegation of its birthright power to tax. Does that framework, how do you think that's going to be received by the legal community?
Well, I think that's probably right. I mean, look, when Congress decides to delegate a power, it has to be clear. The court's engaged in a number of decisions in recent years to make clear that if Congress is going to delegate authority, particularly broad grants of authority with no bounds around them, as the president would read IEPA in this case, it's got to do so with real clarity. It's this whole idea, this major questions doctrine that you've heard a lot of talk about. And so the court's reiterated that a number of times. That didn't used to be the court's view. It is the court's view now. And I think that's where the legal community is going to say, look, we could see this coming from these recent cases, limiting the ability of Congress to delegate its authority and making sure that if it does so, it does so in a very clear, specific way.
I mean, the administration has been prepared for this, right? It didn't come in the first few weeks of the decisions. We sort of knew, and they've got to be gaming this out. I mean, there's Section 232, which is sort of one of the easiest existing authorities that he could use for tariffs. There's also Section 122 of the Trade Act of 1974, where he can do 15% tariffs quickly, but only for a 6-month period. There's Section 338 of the Tariff Act, which allows up to 50% tariffs, but it's never been invoked. Section 301 of the Trade Act. I mean, this is kind of technical stuff, but there are other means for him to impose these tariffs, aren't there?
No, that's exactly right. And so, some of your viewers might be wondering, well, why did the president just go ahead and impose those up front? One, taking the view that they had of IEPA, I think they were thinking a couple of things. One, they could impose broad tariffs, move them around as they chose to, in part because Congress didn't put any bounds on this in theoretical authority in IEPA. They simply said the power to regulate imports. And so as a result, the president said, well, I can tax those imports, I can impose tariffs. That's a form of regulation. Now I've got complete free run room. I don't have to make any findings. I don't have to make any decisions other than there's an emergency going on, and this is my chosen way of solving for it. With all these other statutes, to your point, there are limitations. You have to make certain findings. You have to submit to Congress. You can only do it for a certain period of time. So it just makes it difficult. And so the president's, I think, theory was, if I can get this through IEPA, I've got broad authority. I can keep moving them around. If I make deals, I can reduce it as necessary. And so I think that's the idea here. Now they're going to have to go through. They probably do. If the administration was planning ahead, which I think I'm sure they did, they probably got a plan for how they will re-implement a number of these through these new authorities. They'll just have to go through the process of doing that. They probably have a break the glass plan ready to go, and they'll deploy it in the next hours, days, weeks.
What do you make of, I mean, from a legal perspective, the whole idea that we were just talking about before you came on of these refunds? Because I would assume the courts will be involved here as well in some fashion. It's very much unclear to any of us exactly how that would work. Do you have any ideas, Jamil, in terms of what at least a sequence of events may occur as a result of that?
This is exactly the right question to be asking. I think the question the administration is trying to raise is saying, look, the court shouldn't make the mistake of doing this. It's going to be a huge debacle to have to get these refunds back to people. And yet now we're in that position. The court did not take up that idea that simply because it would be hard, the court can make a decision on the law that it doesn't think is correct. And so the administration, again, hopefully has been preparing for this day, has a plan now how to do it. But what will ultimately happen, I think, is it'll go down to the lower courts. The lower courts will then have to handle this one specific case that's before them and provide the refund in that case. And then the question is, will the administration create a mechanism for all other similar situated plaintiffs? Will they wait for the court to come in and impose a requirement like that in some sort of a broader suit, or people have to sue individually to get their money back. And, it's open season right now. We don't know for sure. And I think that in part was why the administration was saying, you're going to cause a whole lot of trouble if you do this. And the court, I think rightly, said, look, we're going to do the law. You all figure out the consequences.
Yeah, that's there was so much sort of parlor gaming around the supposed delay, the length of the time. We thought we were going to get this decision, some thought November or December. And per our earlier discussion, Jamil, about restitution, how do you think we should think about the lack of consumer restitution? This is going to be a corporate restitution story.
Well, that's the really interesting situation. Obviously, the president has made the argument that, in fact, the economy is doing better, that the economy is expanding, and that the tariffs have actually been paid by other countries. That's, I think, a debated proposition. The Fed came out with some numbers earlier this week that suggested that wasn't as true. We had seen some earlier numbers, by the way, that did suggest that consumer prices have not gone up as much as we had thought. So the answer to that question about how much consumers have paid is a little ambiguous. Although I think the general economic consensus is that ultimately, whether it's today, tomorrow, or next year, consumers will pay the price of those tariffs. And so now, because the companies are going to get reimbursed, the one party that's out on these tariffs will be ultimately the American consumer. So whatever higher prices we did pay, we won't see that back. The president may have to scramble now, particularly as we're in the lead up to a midterm election. He may try to go to Congress and say, look, let's give the American people a tax refund of some sort in order to address this concern. But that will require an admission that American people have paid higher prices. He hasn't been willing to say that yet thus far.
Jamil, do you think this has any implication or bearing on the trade deals that have been negotiated under this whole tariff framework?
Well, I don't think so, because, the countries have come to the table. They've made deals with the United States. They've made agreements. Those agreements are as binding as anything else. They're executive agreements. They're not like they're treaties. But the countries could bail out on them. I think they would do that at their peril, because you'll see the president use other authorities to come in and levy, sort of punishment upon those countries if they walk out. So the deals are still in place. They may now not, the countries that haven't made deals, or the countries that have made deals and they see another tariff in the future, or a threat of a tariff, they may look, questioning at that. But the president has a number of authorities, as we were discussing earlier, as you raised. And so, look, at the end of the day, he's got a lot of tools in his toolkit. He just chose one that was very broad. He now doesn't have that one taken away. And now we're going to see how this plays out. And by the way, the president has a lot of other toolkits to put pressure on other countries to do trade deals beyond just tariffs. He's chosen that one because it was effective and it did the job.
Yeah, although implementing those alternative tools is going to introduce perhaps some more volatility into trade policy and certainly the markets. We'll see what that brings us. Jamil, thank you for the help on that important discussion.